of Mr. Mapisa, accused number 4, before court. Thank you.
As a court, please, my lord, when the matter was adjourned on Tuesday, the state signaled its intention to cross-examine Mr. Ncube on the cell phone data of Mr. Mabungu Ntuli. We then, my lord, just out of common courtesy, indicated to our friends that we intend to canvass the issue of Mr. Mabungu Ntuli's cell phone records and movement with Mr. Ncube. We didn't have to do that, my lord, just out of common courtesy. And our learned colleagues then indicated that they will be objecting to us canvassing the movement of the device of Mr. Mabungu Ntuli with Mr. Ncube. The court then invited us to file his of argument, and we have availed ourselves of that invitation to file the heads of argument, and we will then argue the matter from our heads. In paragraph 1.1 of our heads, which we also furnish a copy to the court, we indicate, my lord, that the state has signaled its intention to cross-examine accused number 3 using the cell phone data of Mr. Mabungu Ntuli, which are contained in an allied docket, namely Cleveland CAS 96/2/2015, in which Mr. Ncube was the accused. We point out, my lord, that the contents of this docket were disclosed to the defense more or less at the same time when the main case docket, First Lawrence CAS 636/10/2014, were disclosed to the defense. My lord, as we have already pointed out, there's really no obligation upon the state to give advance warning of the material that the state wants to use when cross-examining an accused person. We just did that, my lord, simply out of common courtesy, so that we are not said to be ambushing an accused person. My lord, the reason why we want to canvass the issue of Mr. Mabungu's movement, as shown by his cell phone records, is simply the following. and that bears on the issue of relevance. And we make this submission, my Lord, with the greatest respect that there's a tendency to conflate relevance, which goes to admissibility, as well as weight to be attached to an issue. As a starting point, my Lord, we wish to refer to Section 210 of the Criminal Procedure Act and 51 of 1977. We are going to briefly read the contents of Section 210 record. We have done so before. Section 10 reads as follows: no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point or fact at issue in criminal proceedings. And the reason, my Lord, why we're referring to this section is we are of the considered view that the issue of the cell phone records of Mr. Mabungu Ntuli goes to relevance. And as we'll be taking the court through our heads, we'll demonstrate that why we say that the cell phone record of Mr. Mabungu Ntuli are relevant. And reading from HIMSRA Criminal Procedure, which we also quote in our heads on pages 24, 12, the learned author states as follows regarding the issue of relevance. It says that evidence that contributes to the proof or disproof of a matter in dispute is relevant and includes evidence that directly proves points in issue and those from which proof of a point in issue can be inferred. All other evidence is irrelevant. Now, we will make the submission, my Lord, that the movement of the device of Mr. Mabungu Ntuli is relevant. It goes to the heart of the defense of accused number 3, and to a certain extent, accused 4 and 5, namely that on the morning of the 26th of October, 2014, Mr. Mabungu Ntuli was part of the persons who were traveling in a combi from the Johannesburg city center together with accused number 3, accused number 4, and other persons, that they proceeded to Spruit Katlehong at Mazibuko Hostel, and thereafter to Fosslores, a place called Liseding, and that later that day they made their way back to Johannesburg, stopping over at the station at George Koch, near George Koch Hostel, then pick up accused number 5, then proceeded to George Koch Hostel. Thereafter, they, according to the evidence, then returned to their place of abode. And that certain photos were taken during the day at Mazibuko Hostel and also at George Koch Hostel, and that Mr. Mabungu Ntuli was the person who was using the device of accused number 3 to take those photos. So, my lord, it is on that basis that we submit that the cell phone records of Mr. Mabungu Ntuli are of critical importance as they go to the heart of the defense of accused number 3. And once again, my lord, we want to buttress this point that relevance and the weight that must be attached to the evidence should be kept separate. At this point in time, the only issue is relevance. And an issue is relevant if it bears relation to the issues that are in dispute, if the court can be assisted through that evidence in determining the issues that are in dispute. As to what weight to attach to such evidence, as whether such evidence is reliable, that will be an issue that will be determined right at the end of the case when such evidence is weighed up against the totality of the evidence. We then proceed to paragraph 1.2 of our heads, and we point out that it is common cause that Mr. Ncube, accused number 3, was arrested on the 9th of February 2015 at 81 Persimmon Street, Malvern, in the Cleveland area for possession of firearm and ammunition. We've led the evidence of both Sergeant Dlamini and Masondo on this aspect. It is also common cause that his cell phone was also confiscated, and the case docket Cleveland CAS 9/2/2015 was then registered at Cleveland Police Station. We have exhibit triple G1, which indicate that the investigating officer in that case applied for Section 25 data from Vodacom to establish communication between Mr. Ncube on his number 072-7668169 and his associates, which, my lord, will include, amongst others, Mr. Mabungu Ntuli, on the cell phone number 0791490821. Now, my lord, we have led the evidence of Sergeant Mabasa in this respect, and he testified about the download of the device of Mr. Ncube. But more importantly, my lord, he referred to the communication chart which was attached to his affidavit, my lord, that forms part of Exhibit S. He also, my lord, referred to the spreadsheet of the communication between the device of accused number 3 and other persons, and that we see in Exhibit S, Annexure A. And my lord, if one looks at Exhibit X, Annexure A, the number of Mr. Mabungu Ntuli appears thereon. And my lord, how do we know that that is the number of Mr. Mabungu Ntuli? Accused number 3 himself has said that the number 079-149-0821 belongs to Mr. Mabungu Ntuli. That was placed on record when we were dealing with Exhibit G1, the Section 205, pertaining to his device, that this number belongs to Mr. Mabungu Ntuli. For instance, when we look at Exhibit G1 on the 26th of October 2014, there's an outgoing call from his number 072-766-8169. There is an outgoing call, an MOC at 1429 lasting 47 seconds, and the tower is 2G Phosphorus. Mr. Nube himself placed on record that that number belongs to Mr. Mabungu Ntuli. And also when Colonel Stein attributed this number to accused number 5, Colonel Stein was corrected, and it was placed on record that that number belongs to Mr. Mabungu Ntuli. And my lord, if we look at Exhibit S, Annexure A, the spreadsheet that forms part of the affidavit of Surgeon Mabasa, the number 079-149-0821, which accused number 3 himself says belongs to Mabungu Ntuli, appears about 25 times on this spreadsheet. And coming back to our heads, my lord, at paragraph 1.3, we point out that this data was always there under the Cleveland case docket, and that after accused number 3 had confirmed his version under oath that on the 26th of October 2014 he was with Mr. Mabungu Ntuli, and we've already indicated this on Tuesday, my lord, that we then decided on the 17th of August 2026 to verify the movements of Mr. Mabungu Ntuli as per the tower information for the number 079-149-0821. And we've already put on record, my lord, that we access this data from Vodacom on the 17th of August 2026, and that we now intend to use this data to cross-examine accused number 3. See, Advocate Mshololo in her heads makes heavy weight of the fact that the state did not explain as to why the evidence was not led through Ms. Fillingham. We have indicated that we became aware of the evidence on the 17th of August 2026. Then at paragraph 1.4, that even during the cross-examination of accused number 3 by Mr. Ramosepeli for accused number 2, Mr. Ramosepeli referred to the photo album as well as an affidavit contained in Cleveland case 9/2/2015, information that is contained in Cleveland 96/2/2025, and quoted the affidavit of the analyst, Warrant Officer J.M. Motsaba, an analyst attached to the Brixton War Room. The court will recall that Mr. Ncube then promptly indicated that he does not want to focus on 2 cases at the same time. And that line of cross-examination was then abandoned. So even the defense themselves have referred to the contents of this Cleveland docket 96/2/2015. At paragraph 1.5, we mention that there is an affidavit by the investigating officer where he applies for Section 2.5 records for the cell phone records of inter alia, the cell phone number 0791490821, which, as we've indicated, belongs to Mabungu Ntuli. We see in their heads the defense through Advocate Mshololo say that the affidavit of the investigating officer hasn't been placed on record. But this is part of the package, my lord, that if we are allowed to dive deep and cross-examine Mr. Ncube on the cell phone data of Mr. Mabungu Ntuli, will be canvassing. On page 3, my lord, we deal with the extent and purpose of cross-examination. We refer to the work of the well-known author, A. Creer, Himstra's Criminal Procedure Act, the March 2026 version at pages 22 and 52. This is the work that we have just quoted. Even on Tuesday, my lord, when we foreshadowed the intention to cross-examine Mr. Ncube on the cell phone data of Mr. Mabungu Ntuli, we also referred to this part, and we are going to quote it. It says, the law of procedure allows the cross-examiner great latitude. He or she may investigate any relevant topic. In particular, the questioner may embark on an excursive investigation as to the credibility. And my lord, that is the substratum of the state's argument that in cross-examination we can canvass any issue. We can canvass any issue with a witness. The only qualification, my lord, is that that cross-examination must be relevant. And as we've argued, my lord, that this aspect is relevant that we wish to canvass. Then at paragraph 2.2, we refer to the work of a very well-known jurist, G. Coleman, Cross-Examination, a Practical Handbook. It's the 4th edition, 1984, at page 5. He says that the purpose of cross-examination is, and we quote, it's commonly thought of as the one, decide to expose the witness who is deliberately lying. And indeed, it is that. But no less important is the achievement of counsel who demonstrates by cross-examination that the witness has been mistaken on one or more of the points in his evidence, or that he is biased or otherwise unworthy of credence, or that material points have been omitted or inadequately stressed. And even when cross-examination does not succeed in demonstrating matters of this kind, it is helpful if it reveals the probability or sometimes even the possibility that they exist. Courts work on probabilities of various degrees where certainty cannot be achieved. And although destruction of the evidence in chief constitutes success, a cross-examiner or cross-examination may be equally valuable if it does no more than raise doubt about the reliability of the witness or the accuracy of his evidence on material points. And we close the quotation, and that's precisely, my lord, all that we are seeking. We are going to use the cell phone data of Mr. Mabungu Ntuli to challenge the version of accused number 3. At paragraph 2.3, we also refer to the work, very locus classicus of Ditoi and others, commentary on the Criminal Procedure Act 2025 at pages 22 to 79, wherein he states, and we quote, cross-examination is one of the essential components of the adversary's system of procedure, and he refers to the well-known author on evidence Wigmore at paragraph 1367, and Wigmore on evidence calls it the greatest legal engine ever invented for the discovery of the truth. The cross-examiner is not limited to matters covered by the witness in examination in chief. And that is, my lord, our main contention, that we can cross-examine a witness on anything, not necessarily the issues that were covered in evidence in chief, with this rider that such cross-examination should be relevant. Effective cross-examination is of particular importance where the evidence is entirely circumstantial, as the court explained in State versus Shaw, an unreported case of the KwaZulu-Natal division, that, and we quote, testing all reasonable possibilities fully is indispensable not only for discrediting evidence and for enabling the witness to refute attacks on their credibility, but also for eliciting for the trier of fact, and this refers to the court itself, not speculation, but explanations which, if reasonable, would enable appropriate inference to be drawn. Failure to examine effectively may not only bar a party from later seeking to draw inferences from facts not attested to or disputing the truth of a witness' evidence, but also impair the ability of the trier of fact to draw the most reasonable inferences. So in other words, the court here said cross-examination where the evidence is of a circumstantial nature also enables the court to draw the most reasonable inferences. Then at paragraph 2.4, we deal with the case of State versus Msimango and another, 2010, volume 1, SACR, decision of the Gauteng Local Division by Judge Mushidi, as he then was. And at page 4, he cites the definition by Webster, Third International Dictionary, 1993, and we quote, "To cross-examine is to examine a witness who has testified for the other side in a legal action, especially to disprove testimony already given." But as we've indicated, my lord, this cross-examination is not only limited to testimony already given, but all aspects that are relevant to the issue in dispute. And at page 5, it continues, "The right to cross-examine is tried in our criminal justice system. Curtailing it inappropriately or interfering with it may render a trial unfair, vitiating the entire proceedings." And at page 5, paragraph E, "Indeed, the importance of the right to cross-examine in any disputed hearing, particularly in an adversarial system such as ours, can hardly be overemphasized." And the learned judge then refers to the case of Carroll versus Carroll, 1947, volume 4, SA 37, decision of the Durban Local Division, at page 40, where Hennesbeck J. as he done was held as follows, and we quote, "The object sought to be achieved by cross-examination are to impeach the accuracy, credibility, and general value of the evidence given in chief, to sift the facts already stated by the witness, to detect and expose discrepancies, and to elicit suppressed facts which will support the case of the cross-examining party." And as we've indicated, my lord, that cross-examination is the most potent weapon to discover the truth, even facts that have been suppressed. Paragraph, and we submit, my lord, that the cell phone data of Mr. Mabungu will paint a completely different picture from and put a different complexion on the matter from what Mr. Ncube has stated. In paragraph 2.5, the state contends that the movement of the device of Mr. Mabungu Ntuli on 26 October 2014 is crucial to test the version of Mr. Ncube that he, that is Mr. Ncube, was with Mr. Mabungu Ntuli from morning till evening on the 26th of October 2014. At paragraph 2.6, we refer to a very old but very pertinent decision, the case of R versus Ndao and others, 1961, volume 1, South African Law Reports, and it's the decision of the then Natal Provincial Division. At page 16, paragraphs C to D, the court held that, and we quote, when once a witness is called and a party makes that person his witness, he may be cross-examined by the other side, and a denial of that right of cross-examination is an irregularity. And at page 17, paragraph C to D, the purpose of cross-examination is to enable the other side to prove their case through the witness called by the opposing party and to search what is concealed. And that is all, my Lord, that we are seeking to do. We'll be using the cell phone data of Mr. Mabungu Ntuli to search what might be concealed. Then on page 5, my Lord, paragraph 2.7, we refer to the case of the Stilas Corporatie, PTD, Pty Limited versus Kote, 1956, volume 1, SA 357A, the decision of the Appellate Division, the then Appellate Division, now Supreme Court of Appeal, at paragraph C, the court held that, and we quote, where the orthodox rule obtains today, that is, permitting cross-examination as to any matter embraced in the issue, and we emphasize this fact, my Lord, any matter that is embraced in the issue, which, my Lord, we submit the cell phone data of Mr. Mabungu Ntuli are, then at 362D to E, the court held that, however that may be, there's no reason to doubt where the orthodox rule applies. Today, there's no discretion in the trial judge to limit the scope of cross-examination to the topics upon which there has been examination in chief or allied topics. And we emphasize that aspect, my Lord, and allied topics will refer to the issues that perhaps might not have been canvassed in examination in chief. And at paragraph 2.8, we deal with the defense contention that this constitutes new evidence, but perhaps maybe before that, my Lord, in their heads, Advocate Msholol points out that in allowing cross-examination on this point will result in prejudice to the accused. Our submission, my Lord, on this point, that there can be no prejudice. That has been the version of accused, 3 until 5, that Mr. Mabungu Ntuli was present on the 26th of October 2014 from morning till early evening, that he took certain pictures that form part of Exhibit S. Unless, my lord, if they are contending that they, and we're saying this with the greatest of respect, that they would have had to tailor their version according to the cell phone records of Mr. Mabungu Ntuli. But we submit with the greatest of respect, my lord, that that has been the version from the outset that Mr. Mabungu was present. So the cross-examination on the cell phone records of Mr. Mabungu cannot be said to result in any prejudice. But be that as it may, my lord, they will have the opportunity to re-examine Mr. Ncube, and they can then fully canvass those aspects with him. Coming back to our heads at paragraph 2.8.1, we have indicated that cross-examination is not limited to matters covered by the witness in examination in chief, but allied or relevant topics may be canvassed. We make the submission, my lord, that the movement of Mr. Mabungu Ntuli's cell phone or device on the 26th of October 2014 is not really a new topic. It was posited to some of the witnesses that accused number 3 and 4 were with Mr. Mabungu Ntuli and other people in a combi where they drove from Johannesburg to Spruit in Katlehong at Mazibuko Hostel. And here we refer to Exhibit S, the photo on page 9, and the same photo appears on page 175. And that the Kumbi then later traveled to Fossilores at Lesedi, and here, my lord, we refer to photos on page 47 and 48 of Exhibit S as photos that were taken there. That they returned to Johannesburg and pick up accused number 5 at the station at George Koch and went inside George Koch Hostel. That a photo on page 17 of Exhibit S depicting accused number 3 and 5 was said to have been taken at George Koch Hostel by Mr. Mabungu Ntuli. A photo on pages 34 and 46 of Exhibit S depicting 4 persons was allegedly taken on the morning of the 26th of October 2014 near Corner Main and Nugget, Johannesburg. Where accused number 3 and 5 are said to have resided with Mr. Mabungu Ntuli and Spiva Ntuli, and was said to be depicting the following persons. We're just trying to put that photo on the screen. That Mr. Spiva Ntuli is the person on the left of the photo. that Mr. Mabungu Ntuli, it's the person next to Mr. Spiva Ntuli. That is the photo, my lord, that we're referring to. That forms part of Exhibit S, that the person on the left-hand side of the photo is Mr. Spiva Ntuli. Then Mr. Mabungu Ntuli is the person next to him. Then Mr. Mapisa is the third person, and Mr. Nube, the fourth person on the extreme right. Then a photo, my lord, which forms part of Exhibit S, pages 9 and 175, was alleged to have been taken by Mr. Mabungu Ntuli. Sorry, my lord. We just want to show that photo. This photo was alleged to have been taken by Mr. Mabungu Ntuli at Mazibuku Hostel at Spruit Katlehong on the 26th of October 2014 at 11:52, using the phone that belongs to accused number 3. In paragraph 2.8.2, we make the submission, my lord, that the movement of Mr. Mabungu Ntuli's phone with the number 0791490821 on the 26th of October 2014 is not a new topic. And we refer to extracts from the records to demonstrate this point. The first bullet, we say, and we've already referred to this, my lord. The first bullet, Exhibit S, Annexure A, is the analyst notebook spreadsheet, and we, as we've already indicated, Sergeant Mabasa testified about that. And we see that in the record of the 1st of August 2023, page 52, lines 1 to 9. Then the second bullet, this issue was also canvassed during the cross-examination of Constable Zungu by Advocate Numalo, as per the record of 2 October 2023, page 56, line 2, and lines 15 to 19, where a proposition was made to Constable Zungu that Mr. Mabungu Ntuli is the person who was taking the photo on page 47 of Exhibit S at Lesedi Fossilores. Then the third bullet, this is where a photo was taken near a red vehicle which allegedly belongs to Mr. Namuza Gumede. Then the third bullet, also during the cross-examination of Ms. Faithilingam by Advocate Numalo, as per the record dated 24 July 2024, page 80, lines 10 to 25, to the effect that the photo on page 9 of Exhibit S was taken on the 26th of October 2014 at 11:52, and that they were at Mazibuku Hostel at Spruit or Katlehong, and the person who took the photo is Mr. Mabungu Ntuli himself. Then the next bullet, also during the cross-examination of Ms. Faithilingam by Advocate Numalo, on the record of the 24th of July 2024, that Mr. Mabungu Ntuli is mentioned as the occupant of a minibus with Mr. Nube, Mapisa, and several other people when they departed in the morning of 26 October 2014 from Johannesburg to Mazibuko Hostel at Spruit. Then on page 7, also during the cross-examination of Ms. Faithilingam by Advocate Nisi, as per the record of 23 July 2024, pages 51 to 52, lines 10 to 25, and page 52, lines 1 to 25, to the effect that Mr. Ncube was staying at the corner of Main and Nugget Streets, Johannesburg CBD, and that on the morning of 26 October 2014, Mr. Ncube, Mr. Mapisa, and Mr. Mabungu Ntuli, together with other persons, departed from Johannesburg CBD in a combi to Spruit in Katlehong. Then paragraph 2.8.3, we indicate that even if it can be argued that the cell phone data indicating the movement of Mr. Mabungu Ntuli's cell phone on the 26th of October 2014 is a new topic, we make the submission, my lord, that it can be canvassed at any stage of the hearing, as we have already argued. And we refer to the case of Mulala, unreported judgment of the SCA, case number 074/2014. Judgment was delivered on the 29th of August 2014, where the SCA allowed new evidence in the form of affidavits on appeal. I see in their heads, Advocate Mshololo contends that we did not satisfy the 3 requirements that are mentioned in Mulala's case. She mentioned, 1, that there must be a reasonable, sufficient explanation why the evidence sought to be introduced was not led during the state case. B, that there should be a prima facie likelihood of the truth of the evidence. Cell phone evidence is objective evidence. Thirdly, the evidence should be materially relevant to the outcome of the trial. We've already argued that point. We are therefore submitting, my lord, that this situation is on all fours with these 3 conditions that were set out in the case of Mulala. Then paragraph 3, we deal with the admissibility of evidence of cell phone records from the service provider. Paragraph 3.1, we refer to section 15, subsection 4 of the Electronic Communications and Transactions Act 25 of 2002, which provide as follows, and we quote, a data message made by a person in the ordinary course of business, or a copy or printout of or an extract from such data message certified to be correct by an officer in the service of such person is on its mere production. And we want to emphasize that, my lord, on its mere production in any civil, criminal, administrative or disciplinary proceedings under any law, the rules of a self-regulatory organization or any other law or the common law, admissible in evidence against any person, and rebuttable proof of the facts contained in such record, copy, printout, or extract. So in other words, my lord, cell phone evidence which we contend that it falls within the definition of a data message is just by mere production thereof, proof of the contents thereof. Paragraph 3.2, we deal with Section 1 of the Electronic Communications and Transactions Act, which defines a data message as data generated, sent, received, or stored by electronic means, and includes a voice, where the voice is used in an automated transaction and stored on record. And at paragraph 3.3, my lord, we make the submission that cell phone evidence falls within the ambit of data message and that is therefore admissible on its mere production. Then, my lord, in the last segment of our heads, we refer to the relevant case law. We have referred on Tuesday to this case of the National Director of Public Prosecutions versus King, decision of the SEA, case number 86/09, judgment delivered on 8 March 2010, where the court held as follows at page 4, and we refer to paragraph 5. There is no such thing as perfect justice, a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in criminal cases must always be a compromise. Fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impracticable to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems, or to encourage preliminary litigation, a pervasive feature of white-collar crime cases in this country. On the contrary, courts should, within confines of fairness, actively discourage preliminary litigation. Courts should further be aware that persons facing serious charges and especially minimum sentences have little inclination to cooperate in a process that may lead to their conviction. And any new procedure can offer opportunities capable of exploitation to obstruct and delay. One can add the tendency of such accused, instead of confronting the charge, of attacking the prosecution. Then we deal with this overarching aspect of the interest of justice, that it is in the interest of justice, my lord, that we be allowed to canvass the cell phone records of Mr. Mabungu Ntuli with Mr. Ncube. At paragraph 5.1, it is respectfully submitted that it is in the interest of justice to allow the state to cross-examine Mr. Ncube on the cell data and movement of the phone of Mr. Mabungu Ntuli, in light of his version that they were together on the 26th of October 2014 from morning till evening, and that Mr. Mabungu Ntuli took some of the photos as we have indicated above. And we also refer to the locus classicus of R versus Hepworth that has often been quoted by the court. 1928 AD 265 at 277, the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. And we make the submission, my lord, that justice will be done if the state is allowed to cross-examine Mr. Ncube on the cell phone movement of the device of Mr. Mabungu Ntuli. We refer to the case of State versus Sheikh and others. We give the reference there where the court held as follows. The applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. And we also refer to the case of multi-choice and others versus the National Prosecuting Authority. We give the citation there. Judgment delivered on 25 February 2014 by the Supreme Court of Appeal at paragraphs 13 and 17, where the court held as follows. That our Constitutional Court has been vocal regarding the protection of the right to a fair trial. And my lord, in terms of the Constitution, the right to a fair trial also encompasses the right to challenge evidence from the perspective of the accused. So the right to challenge the evidence is also recognized in Section 35 of the Constitution. The court held that our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And referring to the case of State versus Zukuza and others, the court further held that a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair trial, fair criminal trial, and what infuses its purpose is for justice to be done and also to be seen to be done. And we submit, my lord, that justice should be allowed to prevail in this matter regarding the issue that we have raised to cross-examine Mr. Nube on the movement of the cell phone of Mr. Mabungu Ntuli. And finally, in paragraph 5.5, we refer to that case of State versus Dlamini, where Judge Kriegler described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my lord, that it will be in the interest of justice that we be allowed to canvass the movement of the device of Mr. Mabungu Ntuli with Mr. Nube. This is as far as we can take our argument. 11:28. 11:28. Yes, 11:28. It's time for the short adjournment.
Izithulo besifundwa ngumshushisi ngaphambi kokuthi njena ukuthi isikhathi sethi uthi-ke bavezile noma bashilo-ke bengabashushisi inhloso yabo yokuthi-ke bahlome imibuzo umnumzana uNcube besebenzisa-ke imininingwane kamakhalekhukhwini kwicala-ke eCleveland noma-ke kwidokodo lecala lase-Cleveland 296/2015 la khona-ke umnumzana uNcube wayewumsolwa khona okulapho-ke noma-ke okukhona ngaphakathi kulona idokodo lolo abameli-ke bakunikwa konke kuphelele ngesikhathi-ke salo icala leli kuyi-Phosphorus 363610 ka-2014 kuyinto futhi-ke engaphikiswa leyo muntu-ke leyo ukuthi umnumzana uNcube umsolwa wesithathu waboshwa zi-9 kuFebruary 2015 eboshelwa-ke e-81 Persimmon Street eMalvern kwindawo-ke yase-Cleveland eboshelwa-ke ukutholakala nesibhamu kanye ney'nhlamvu umakhalekhukhwini wakhe-ke nawo wathathwa-ke amaphoyisa kwase kuthi-ke idokodo lecala u-96/2 ka-2015 lase liyabhaliswa-ke epolice station yase-Cleveland umphenyi noma-ke umseshi walo icala lelo wenza-ke isicelo sakhe-ke usection 205 semininingwane kamakhalekhukhwini kwa-Vodacom ukuthola-ke ukuxhumana phakathi kwa-Mr. Ncube kwinamba yakhe 0727668169 kanye futhi-ke nalabo-ke akhulumisana nabo-ke noma-ke abantu-ke asondelene nabo phakathi kwabo-ke uMabhungu Ntuli i-cellphone number 0791490821 le mininingwane yayikhona-ke nangaphansi kwalo-ke icala noma kwidokodo kwicala lase-Cleveland emuva kokuthi-ke umsolwa eqinisekisile-ke inkulumo yakhe ngaphansi kwesifungo nge-26 October 2014 ukuthi wayekanye naye-ke uMabhungu Ntuli umbuso-ke uthe ngazo i-17 August 2026 waqinisekisa-ke umnyakazo-ke wakhe uMabhungu Ntuli ngokwemininingwane yethawa noma befuna ukuthi baqinisekise-ke iminyakazo noma umnyakazo wakhe uMabhungu Ntuli ngenamba 0791490821 umbuso-ke noma abashushisi-ke bakutholile-ke lokho kwa-Vodacom nge-17 zika-August 2026 manje-ke inhloso yabo ukuthi-ke bahlome yena-ke umsolwa wesithathu ngemibuzo emuva kokuthi-ke sebeyitholile leyo mininingwane ngabo ubufakazi lobo futhi-ke nangesikhathi umsolwa wesithathu ehlonywa imibuzo uyena-ke umnumzane uRamusipile omele umsolwa wesibili umnumzane uRamusipile wakhuluma-ke ngesithombe noma-ke i-album yey'thombe kanye futhi-ke nencwadi efungelwe noma-ke isitatimende esifungelwe esikhona-ke kwicala leli lase-Cleveland 296/02/2015 ekhona futhi-ke kulona icala leliyana lase-Cleveland wase futhi-ke ekhuluma ngayo i-affidavit leyo yakhe-ke lowo owumcwaningi u-warrant officer J.M. Muchaba uyena-ke osebenza-ke ngaphansi kwe-Brixton War Room umsolwa wesithathu wase esho-ke ukuthi akafuni ukuthi-ke agxile noma-ke akhulume ngamacala amabili ngesikhathi esisodwa khona futhi incwadi efungelwe noma-ke isitatimende la khona-ke umphenyi noma umseshi wecala enza isicelo khona-ke ngaye u-section 205 ngama-cellphone records phakathi kwazo-ke kuyinamba 0791490821 inhloso-ke noma-ke abahlosile ukuthi-ke babuze ngabo noma-ke uma bezohloma imibuzo abeshushisi bakhulumile-ke ngecala lakhe-ke uKruger March 9 okay ngaphansi kwakhe-ke uHimstra kwincwadi-ke ephathelene nezomthetho la khona-ke ichaza khona ukuthi inhloso ukuthi-ke kubuzwe imibuzo ukuthi-ke kungani-ke nokuthi-ke futhi-ke loyo-ke ukuthi-ke umgomo uyabavumela-ke noma-ke inhlolomgomo uyabavumela ukuthi-ke basengaphenya-ke nanoma yisiphi isikhathi uma ngabe kunodaba-ke ngesikhathi sokuqulwa kwecala ekufanele-ke ukuthi-ke kuphenywe ngako bafundile futhi nangaphansi kwakhe-ke uColeman futhi naye amacala nje ahlukahlukene abawasebenzisa njengoyibonile noDutoy ufundiwe naye umsimango ukhona naye kulawo macala nondawo bese beza ke udaba ke lokuthi ke abameli bona ke bathi cha udaba olusha lolu abavumi ke abameli ukuthi ke abashushisi babuze ngalo daba ngoba udaba olusha base bephendula ke abashushisi ifundeka ngalendlela ukuthi nanje ngoba besho ke la ngaphezulu ukuthi ke ukuhlonywa kwemibuzo akusiyona ke into ephelela nje kuphela ke kuloko ufakazi akhulume ngako ngekathi ke ethula ubufakazi bakhe obuyinhloko kodwa ke futhi nokunyeke nako okuhambisanayo ke nako kusengathi ke ahlonywe imibuzo ngako umnyakazo wamabhungu yakhe umabhungu ntuli nge-26 zika October 2014 akusilona udaba olusha into ke leyo eyakhulunywa into eyashiwe kwabanye bofakazi ukuthi ke umsolo wesithathu nomsolo wesine babe ndawonye naye umabhungu ntuli kanye futhi nabanye abantu behamba ngalo itekisi la abasuka khona eGoli eJohannesburg ukuya eSpruit eKatlehong emazibuko hostel akubukwe ke isithombe 9 noma ke isithombe ku page 9 lesi ke besikhondisiwe khona lana kanye futhi ke no page 175 naso ke besikhondisiwe njengaphambi kokuthi ke siye ke kwisikhathi setiye kamuva ke base baya eFosloras elisedi isithombe salapho ke 47 no 48 base bebuyela khona ke eGoli ila abaxosha khona ke umsola wesihlanu esteshi eGeorge Koch base bengena ngaphakathi ke ehostel eGeorge Koch isithombe ke esiku page 17 ka exhibit S sikhombisa ke umsolo wesithathu kanye naye umsolo wesihlanu ukuthi ke kwakuse George Koch lapho ehostel nokuthi ke futhi umuntu ke washutha ke isithombe le kwakuyena umabhungu ntuli isithombe ke ku page 34 kanye naye ke 46 sakhe exhibit S sikhombisa ke abantu abane sona ke sashuthwa ke ekseni ngazo i26 October 2014 eduze ke kwekhona iMain no Nugget eGoli la khona ke umsolo wesithathu nomsolo wesihlanu kushiwa ukuthi yila ababehlala khona kanye naye umabhungu ntuli kanye futhi noSiphiva ntuli nokuthi ke abantu abakhona kuleso sithombe leso uSiphiva ntuli kwisandla sakho sokunxele umabhungu ntuli eduze kwakhe bese kuba uMaphisa umsolo wesine kanye futhi ke nomncube yena ke kwisandla sakho sokudla kusona isithombe leso ukuthi uyena ke umuntu wesine isithombe ke ku page 9 make 175 wakhe uexhibit S kuyashiwo ke ukuthi sathathwa noma sashuthwa uyena umabhungu ntuli zibuko hostel eSpruit eKatlehong nge-26 October 2014 isikhathi ku-11:52 esebenzisa umakhalekhukhwini wakhe umsolo wesithathu ngako ke umnyakazo wakhe umabhungu ntuli ne-cellphone number 0791490821 nge-26 October 2014 akulona udaba olusha futhi ke amarekhodi ke ahambisanayo ke nalokho uma ngabe kubukwa yona ke exhibit S annexure A incwadi ke ebizwa ngokuthi analyst notebook spreadsheet bona ke ubufakazi bakhe uSergeant Mabasa ngokwerekhodi idate u1 August 2023 upage 52 amaline ke u1 yofica ku9 ubone futhi ke ubufakazi noma ke ukuhlonywa kwemibuzo wakhe uConstable Zungu buza ke imibuzo uyena uAdvocate Nxumalo ngokwerekhodi idate u2 October 2023 upage u56 uline 2 kanye ke no lines u15 kuyofica ke ku19 la khona ke kwaba nenkulumo eshiwo kuyena ke uConstable Zungu ukuthi umabhungu ntuli uyena umuntu owayeshuta izithombe ku page 47 exhibit S elisedi eFosloras zabantu labo abebimile eduze kwemoto ebomvu imoto leyo ke inkulumo eyayithi ke kwakuyimoto kaNcamuza Gumede bona ke ubufakazi noma ke ukuhlonywa kwemibuzo kwakhe uMiss Vitilingam ebuzwa ke uyena uAdvocate Nxumalo ngokwerekhodi idate u24 July 2024 upage u8 ulines u10 kuyofika ke ku25 mayelana ke nokuthi izithombe noma ke isithombe esiku page 9 wakhe uexhibit S sashuthwa nge-26 October 2014 isikhathi 11:52 nokuthi ke babe zibuko hostel eSpruit noma ke eKatlehong nokuthi ke umuntu okuyena ke owashutha isithombe leso kwakuwumabhungu ntuli ubuke futhi ke ukuhlonywa kwemibuzo kwakhe uMs Vaitilingam uyena uadvocate Nxumalo irecord la nge-24 July 2024 ukuthi ke uMabhungu Ntuli kuyakhulunywa ngaye nanjengomuntu ke owayekhona noma ke owayegibele itekisi noMncube Maphisa kanye futhi nabanye abantu ngesikhathi ke abasuka ngaso ekseni nge-26 October 2014 eJohannesburg ukuya ke emazibuko hostel Esprit. Qhubekeke ubone futhi noma ke ubuke futhi ke ukuhlonywa kwemibuzo kwakhe uMs Vaitilingam uyena uadvocate umnisi ngokwe record la nge-23 July 2024 upage 51 uyofika ke ku-52 lines 10 uyofika ku-25 no page 52 line 1 uyofika ke ku-25 malana ke nodaba lokuthi uMncube wayehlala ekhona Main and Nugget Street maphakathi ke nedolobha eGoli noma ke eJohannesburg nokuthi ke ekseni nge-26 October 2014 uMncube uMaphisa uMabhungu Ntuli kanye futhi nabanye abantu bahamba besuka khona ke edrobheni eGoli behamba ngetekisi ukuya ke eSpruit eKatlehong 2.8.3 nokuthi nanoma ke sekungashiwo ke ukuthi ke umakhalekhukhwini noma ke imininingwane kamakhalekhukhwini isho ke noma iveza ukuthi umnyakazo wakhe uMabhungu Ntuli noma ke i-cellphone yakhe nge-26 October 2014 kuwudaba olusho kodwa ke sekungakhulunywa ke lokho noma kungavezwa ke nanoma isiphi isikhathi sokuqulwa kwecala kwase kukhulunywa ngalo ke icala likaMalala i-judgment ke noma ke isinqumo lapho esakhishwa ke nge-29 August 2014 ukuvumeleka ke kobufakazi bufakazi bakamakhalekhukhwini noma ke irecord ke lakho lokho khuluma ke lapho ke noma ke ikhuluma ke ngemithetho ke ama sections u15 ngaphansi kwakhe ke u4 kanye futhi ke namacala ke ahlukahlukene afundiwe masiza ke ukwenziwa noma ke ukwenziwa kwabo ubulungisa bashushisi bathi ke bayasho ke bona noma kuyinkulumo yabo ukuthi ke akuvumeleke ke ukuthi kuzoba yibona noma ukwenziwa kwabo ubulungisa ukuthi ke abashushisi bavumeleke noma inkantolo ibavumele ukuthi ke bahlome imibuzo kuyena umnumzana uMncube ngokumininingwane kamakhalekhukhwini kanye futhi ke nomnyakazo kwayo ifone noma ke umakhalekhukhwini yakhe uMabhungu Ntuli ngenxa yenkulumo yakhe ukuthi ke babe ndawonye nge-26 October 2014 ukusuka ke ekseni kuze kube ke ntambama nokuthi ke uyena futhi umuntu ke owashutha ezinye izithombe nanjengoba kushiwo ke la ngaphezulu sebekhuluma ke ngamacala kahlukahlukene ke abo Hepworth oShake amacala ke o multi choice abawasebenzisayo ke ukuthi ke inkantolo ibheke wona ukuthi ke ayabavumela noma lawo macala ke bawasebenzisa nanjengeyibonela ukuthi ke ayabavumela ukuthi ke ngempela inkantolo ke ibavumele ukuthi ke bahlomeke imibuzo nabo futhi aboskite kati
Are you still intending to go and see the manager?
Only just call.
Yeah, fine.
Just to see if he's available, Madam.
Quite. So, what time? How long do you need?
Just to make a call and see if he's available.
Yeah,
if
fine.
not, then we can proceed, Madam.
Okay, fine. Okay, so we adjourn until when? 2 o'clock. Okay, fine. 2 o'clock then. I welcome the opportunity, my lord, to also make a few submissions with regard to the issues that are before court. Where do I start, my lord? Let me start here. That our court system in South Africa was not modeled on the idea of there being a winner or a loser. It was modeled on an idea of the interest of justice having been served, my lord. Whether a decision goes against somebody, that somebody is not perceived as a winner. When a decision goes against, or when a decision goes in favor of someone, then that person is not necessarily perceived a winner. Those who understand what interest of justice means would really understand what that means, my lord. My lord, having said that, I have also prepared a document with a view to assist the court, much against what I said on Tuesday, the 18th, where I said that I don't think that I will be filing any document with regard to the issues that are before court. Having reflected on that position, my lord, I realized that I owe this court a duty to be of assistance to it in matters such as this one, my lord. Hence, I filed a document that I think the court would love to have. It's not a very lengthy document, my lord. I don't even think that the state needs to interpret it. Thank you, my lord. Let me start, my lord, with a bit of a response on the submissions that have been made by my colleague, my lord, and start at the very onset of his introduction when he told the court, when my colleague for the state told the court that the movement of Mabungu's cell phone goes to the heart of accused number 3's defense. It's entirely not correct, my lord. And I said it on Tuesday. Unfortunately, I did not have the whole opportunity to finalize what I would have said. I said that was a misconception. It has been repeated here at court again, because on Tuesday it was said that accused number 3 raised an alibi. And I stood up and said, but that's a misconception, my lord. Again, today, it is being mentioned, actually it was mentioned twice in the submission by my colleague, that the movement of Mabungu's phone, a cell phone, goes to the heart of accused number 3's defense. Again, that is a misconception, my lord. Because Mr. Mnube's defense is one of a bad denial. He said, I wasn't there, I don't know what happened there, it wasn't me. That's a bad denial. It cannot be an alibi. So I don't know on what basis does the state premise this submission that the movement of Mabungu's cell phone goes to the heart of accused number 3's defense. We yet have to hear that, my lord. Thank you, my lord. Now, on the issues that are before court here, on whether or not the state can cross-examine a witness on the information that they, on the basis of the fact, let me call it a fact, that they would want to use, which is the movement, as I understood the submission of the state, of Mr. Mabungu's cell phone, my lord. I think the issue is very narrow and is very succinct, my lord. It can actually be formulated as follows. Whether the movement of that cell phone, which is a fact, whether that fact, it's a fact that is relevant to the facts in issue, which is called a facta probantia, or it's a fact that is relevant to the issues themselves, which is called facta probanta. Now, with due respect, my lord, If the answer to those two questions is in the affirmative, then basically the state will have a fun-filled day with with a witness. In other words, they are legitimately poised to cross-examine the witness on the basis of that information. That is, which is a fact that is relevant to the facts in issue, or the fact that is relevant to the issues themselves. Now, the court will basically want to say to me, Mr. Mnisi, may you please assist this court in answering that question? I mean, as an officer of the court, my lord, I need to be very sincere. And having looked at the authority that I've referred to the court to there, in the document that I've just handed to the court, my lord, I honestly cannot find any justification to stand up before this court and say that the fact, the movement of Mr. Mabungu's cell phone on the alleged day does not constitute a facta probanda or a facta probantia. In other words, it does not constitute a fact relevant to the fact in issue or a fact that is relevant to the issues themselves. In other words, it does constitute that fact, my lord. The state has dealt in its submission with the admissibility of evidence that is relevant, with the evidence that is relevant to the fact in issues, with the factors that are relevant to the issues themselves, my lord. I would not go there. Having said that, my lord, as I'm saying, I could not find any authority on which I could rely to say that that fact, which is the movement of Mabungu's cell phone, does not constitute a fact that is relevant to the fact in issue, my lord. Therefore, I would submit that the answer to those two questions, in my view, should then be answered in the affirmative, my lord. Thank you. However, my lord, it does not end up, okay, I've referred to this court to a number of authorities and decisions which are the basis of my submission, my lord. But most importantly is that decision of the Distillers Corporation South Africa, PPK, versus Kotze, which is that 1956 volume 1 decision, SA, the 35, at page 357A. I think that is it's a doyen. That's a decision which is a doyen. It's a maestro, if I put it that way, my lord, specifically on a factor such as this one. But importantly, again, my lord, there is that decision of the South African rugby. No. The state of the president of the Republic of South Africa and others versus the South African Rugby Football Union and others. The court would remember that at that time, the South African Rugby Football Union was led by the late Louis Late, who was the owner of the Ellis Park. Now, a similar question, my lord, also arose in that case. And in trying to address that, the Constitutional Court also had to have regard to the case of Browne versus June. That is an English case, my lord, a very old case. I think it was 1858 or something like that, my lord. The court in that Sarfu case acknowledged that that Browne versus June case forms part of our South African law, my lord. Actually, it has been accepted by our South African system, legal system, the way in which it was dealt with those so many years ago, my lord. I need not go deep into that, my lord, because basically the conclusion is, yes, my lord, in the circumstances of this case, and on the fact on which the state wants to, or the state indicate that they want to cross-examine the witness here, I think in terms of the law, my lord, they are well positioned to do that. However, that is not the end of it, my lord. The admissibility of the fact on which they want to cross-examine this witness, my lord, also it's a factor that needs to be reckoned, that also needs to be taken into account. In other words, the instrument or the document on which the state wants to cross-examine the witness, it's a factor that is also needs to be taken into account. As of now, I don't know what document it is, my lord, but the court will recall that a year or two ago, we had the evidence of Mr. Stein, who came to testify on the basis of a document that was capable of being edited. In one of the so many ways that document was able to find its way into the record, my lord. That was the cell phone records or the Section 205 record of Ms. Kelly Kumalo. The document was capable of being edited. Under cross-examination, Mr. Stein considered that he was not the maker of that document. He was only requested to interpret that document. That document, he received it from the investigating team, and the investigating team indicated that they received that document from their technical support unit, which was the TSU. However, that document was edited, my lord. He couldn't dispute it that it was edited. He only said that, look, he only proffered an explanation and said, look, I did not create this document. I only received it the way in which it was for me to interpret it. That was the request that was sent to me, that I should deal with this document, my lord. Now, as I'm saying, my lord, I haven't seen that document, which is the instrument on which the state wants to cross-examine the witness, my lord. But as I'm saying, the admissibility of that document, my lord, would also be an issue in an event that it gets to be made available to us to go through it, my lord. Very briefly, my lord, if the answer is answered in the affirmative, I've got no other issues to raise again. Thank you, my lord. Those will be my submission. Thank you.
I want to interpret, sir.
Nabanye okhulunywa ke ummeli uadvocate Mnisi kwinkulumo yawo umshushisi utheke udaba lokuthi befisa ukuthi babuzeke nabahloma imibuzo malana ke nomnyakazo wawo umakhala ekhukhwini kaMabhungu Ntuli ngaleli langa ukuthi ke into leyo ke wena noma ke omengayo ke kuloko oyivikela ngako ethi cha ke ummeli akavumelani ukuthi bekuyinkulumo yakho noma ke wena ke ugxile kuloko kwinkulumo yakho nokuthi ke futhi abashushisi bashilo ukuthi ke ngesikhathi wethula ubufakazi kunaloko okushiloko noma inkulumo yakho ikhulumile yokuthi ke wawukuphi nendawo pheceleziko lokwabiza ngokusemthethweni ukuthi ke i-alibi naloko ke advocate Mnisi ethi cha akusiyona ke into noma ke inkulumo ahambisana noma avumelana ngayo okushilo wena nje ngenkathi ke uyikhulumela lana noma ke wethula ubufakazi ukusho nje ukuthi ke cha ukuphika nje konke wena uthi wawungekho kuleya ndawo ngalo ilanga leli ekukhulunywa ngalo ukuthi ke lokho ke into ehambisanayo udaba ke lomakhala ekhuphini kaMabhungu Ntuli naloko okukhulunywa ngako la enkantolo noma futhi nokusho futhi ke ukuthi uyakusho ukuthi ke nanje ngoba bona ke bethi bayimisele ukuthi bakuhlomeke imibuzo ngomayela nemininingwane ngokuthi ke ngempela uMabhungu Ntuli umuntu wayehamba nawe ngalela langa ingakho ke behambile bayofuna ke imininingwane yocingo lwakhe uyashoka ukuthi ke akukho ke akutholile ngesikhathi ke ehamba eyobheka ke umthetho malunga nalo udaba lolu ke lokunyakaza noma lokuhamba hamba kwawo umakhala ekhukhwini wakhe uMabhungu Ntuli nokusho futhi ukuthi ke uma ngabe ehamba noma ke esihlezi phansi ebheka ke umthetho phecelezi ke lokho ngose emthethweni ke ababizwa ngokuthi ke authority noma ke incwadi lezomthetho ukuthi ke cha akukho akutholile yena ke njengo advocate umnisi ukuthi ke cha kuyamnqabela noma ke abamshushisa abavumelekile akushoyo nje kuphela ukuthi lokhu abakhuluma ngako idocument le abathi ke bayimisele ukuthi bakubuze imibuzo ngayo abakayiboni bona bengabameli ukuthi ke babheke ukuthi yini elapho bayijwayeze ke nalokho okubhaliwe lapho kodwa ke uthi cha akukho anako angakunikeza noma ke angakuveza phambi kwalenkantolo ukuthi ke cha abavumelekile ukuthi bakwenze lokho udaba nje kuphela idocument le abayimisele ukuthi ke bakubuze imibuzo ngayo ngoba ke nayo idocument leyo kuyafanele ukuthi ke udaba lwayo lubhekwe ngaphambi kokuthi ke nabo ke bayithule phambi kwenkantolo noma baqhubeke babuze imibuzo ngayo wasenza futhi ke nesibonelo ngayo uKenneth Stein oweza ke la wazokuthula ubufakazi ke ngadocument thizeni noma ke iphepha thizeni awavuma ke noma ke awasho nayo phambi kwalenkantolo ukuthi ke cha kungenzeka ukuthi kube khona ukushintshwa phecelezi ke lokho kubizwa ngokuthi ke uku-edithwa noma kube khona ke imininingwane eshintshekayo kulona lelo document uthi ke mangabe ekhuluma ukuthi ke lana ke sikwisimo esifana naleso ukuthi ke manje asilazi idocument lelo kodwa ke abashushisi bayimisele ukuthi babuze ngalo.
Court, my lord, I think I just missed one point, but thank you, my lord. The applicant with the state now also made mention of the fact that the defense was handed with the Cleveland case at the beginning of the trial, my lord. I'm a little bit constrained speaking on behalf of myself, who represents accused number 1 and number 3, my lord, and who was representing accused number 3, then that is Mr. Mncube. I'm a little bit constrained to agree with the state, my lord, because all that I had when I started to prepare this case was exclusively the Force Lawyers case 636, my lord. The first time I had a glimpse of an information that came from somewhere, and I presume that came from the Cleveland document, my lord, or the Cleveland case, was at the time when I was approached by Advocate Baloyi. It was towards the end of the year, and I'm going to try to repeat what he said. I'm not quoting him verbatim, but this is what he said. He came in the morning and gave me, or us, if my memory serves me well, a document which was a section 205 that relates to Mr. Mncube. And his words were specifically, gentlemen, I am giving you an early Christmas today. This document will go a long way in assisting you in the defense of Mr. Mncube. It turned out later on, my lord, that that document was the section 205 that was read into record by Ms. Vittilingam, and subsequently that is the 205 that we also dealt with throughout this case, my lord. That is the only document that I received in relation to a matter that is not involved in this case, my lord, or that I received from the Cleveland case, my lord. But specifically, his words were, gentlemen, I am giving you an early Christmas today because this document will go a very long way in assisting you in the defense of accused number 3, my lord. Thank you, my lord. That is all that I wanted to say.
Ngikhohliwe Nkosi enkantolo umshushisi ushilo-ke ukuthi udaba lecala leli lase Cleveland noma ke idokodo leliyana ke abameli balinikezwa-ke noma ke kusaqalwa-ke ngalo icala leli-ke eliphambi kwenkantolo manje u-Force Lawyers case 636. U-advocate useyaphendula-ke ukuthi-ke akukhumbulayo yena ukuthi-ke kukhona okunye abakunikezwa noma ke elinye idocument abalinikezwa-ke ingesikhathi-ke ukuthi nje angeke akhumbuleke ilanga kodwa-ke u-advocate Baloyi waza kubona mhlawumbe angeke awasho-ke kube yiwona amazwi noma amagama awasho ebanikeza-ke i-section 205 mayelana-ke ephathelene nayo umnumzane Mncube washo-ke nokuthi-ke i-document leli lizonisiza-ke kakhulu futhi-ke ekuthini-ke nikhulume lona-ke icala lakhe umnumzane uMncube uthi-ke akukho okunye-ke akukhumbulayo noma alikho elinye i-document alikhumbulayo-ke alithola kodwa yilelo nje kuphela elingahlangene naleli icala.
Yeah, it's mine. As the court pleases, my lord, I also am submitting written heads of argument to assist with the issue that we are grappling with at the moment. And before we start, my lord, I just want to perhaps express this, that at the beginning of this process on Tuesday, I would have assumed that my learned colleague, Advocate Sibanda, because he was arguing these matters, that is the one that's going to argue this matter, but I saw this morning that Advocate Baloyi is the one that's arguing these issues. Whilst I understand that they are colleagues, they work together, we must be mindful, my lord, of the decision in the Dr. Death matter when it relates to the engagement of a witness with the parties that are litigants against him as to who he faces. At one stage it was Advocate Sibanda, now it's my learned colleague, but I'll leave it at that. It's just an observation that I made. Now, regarding the issues that are before court, my lord, at paragraph A and paragraph 1 thereof, we say that the state seeks to confront Mr. Mncube with the call data records, which are called CDRs, of Mr. Mabunguntuli, who is now the deceased. And the state says they obtained these call data records in terms of Section 205 of the Criminal Procedure Act 51 of 1977. Now, what I'm going to submit is the following, my lord, that the state has not laid the evidential foundation required for the admission of call data records as real evidence, nor has it complied with the procedural and substantive requirements of the Law of Evidence Amendment Act 45 of 1988 for any content attributed to or dependent upon the said Mabunguntuli, who's deceased. And I must put a rider on my head, my lord, to say we are arguing this in vacuum. As we are arguing now, especially myself, I've never had sight of the call data records that the state seeks to confront the witness with. We were told on Tuesday that we should bring our memory sticks, and then they can be inserted in that memory sticks for us to go and have a look at them. But I haven't done that, and I don't think Mr. Mnisi does have it. I just saw from the document that Mr. Numalo has in front of him, it's got it, and I'll address it towards the end of my heads as well, my lord, that aspect again. Now, at paragraph 2, we say the defense objects to the use of the call data records for the truthfulness of the contents thereof, insofar as the credibility thereof depends on the deceased Mr. Mabunguntuli. And furthermore, we say, my lord, we object on the basis of non-disclosure and procedural unfairness. And I'll show that procedural unfairness when I deal with, my lord will know that I've handed a copy of heads of argument and hot off the press, my lord. I've got the most recent case that deals squarely with the issue that we are grappling with. The case of Thabo Mohapi and others, that's a full bench emanating from the South Gauteng High Court, my lord. And I'm going to submit in my final submissions, my lord, that case is binding on this honorable court because of the stare decisis principles that we follow, my lord. Now, on the question at paragraph 3 of my heads of argument, my lord, I want to stress this, and let that be not misconstrued from Ramosepeli on behalf of Mr. Ntanzi, and in particular on behalf of all the accused persons, because I'm arguing on behalf of everybody here. I did not say the state is not entitled to confront Mr. Mncube with what they want to confront him with. But what we are saying, there are certain jurisdictional factors that must be met before we decide whether this is real evidence, whether this is documentary evidence. And the case of Mohapi, my lord, I'm going to quote extensively thereof. It makes that distinction very clear, and it lays down the jurisdictional requirements that must be met before Mr. Mncube is confronted with the printouts that are supposed to be Section 205 emanating from the Cleveland 96 of 2015 case, my lord. And we submit, my lord, towards the end of paragraph 3, that on the facts of this case, the requirements that are in Mohapi for the admission of the call data records have not been met, and then to run to Section 15.4 of ACTA, the Electronics Communications and Transactions Act 25 of 2002, does not assist the state, and I'll show the court why I say so. Because the state, when it was addressing on this thing, on this ACTA, it only singled out one aspect and says, this is the most decisive. Whilst it is, there's another one that is decisive, because the state stressed the mero motive production of a document in terms of the act as being a decisive, the mere production. But Section 15.4 further says that production must be a certified production of that copy by an employee or an officer from the cell phone company. So we haven't been shown the certification, but these are just the arguments at the beginning, my lord. I'll delve deep into those arguments, and perhaps, my lord, at the end I'll make submissions that are very cogent to say the state is allowed to confront Mr. Mncube, but the state must first go and do as Mohapi says. Now, at paragraph B, my lord, I deal with the fundamental issue that is also associated with what we are arguing here, which is the fundamental distinction between confrontation against proof of contents. And we say, my lord, the South African law draws a very sharp distinction between confrontation and credibility testing against the proof of the truth of the contents. With respect to confrontation, we're saying the state may put a document to a witness to challenge his version, to test his memory, or to lay the basis for an attack on that witness's credibility. And we further say, my lord, that the document need not be formally admitted as evidence, but the witness must be given a fair opportunity to deal with it. Whether Mr. Mncube has been given a fair opportunity to deal with that document, the jury's out on that, my lord. Now, with respect to proof of the contents, we submit, my lord, if the state wants the court to accept the contents of the document as true, for example, that the record shows that Mabungu called accused number 3 at 2019, then we submit, my lord, that the document must be admissible in evidence and the state must lay a proper foundation. And this distinction, my lord, between the confrontation against the proof of contents was crisply explained in the case of Gautini, which is R-A-U-T-I-N-I, versus Prasa, and the citation is on my head, my lord. Here, the Supreme Court of Appeal held that an agreement that, and I quote, all discovered documents are what they purport to be, close quote, serves a legitimate purpose. It allows documents to be discovered as real evidence, that is, the physical object is what it appears to be. However, my Lord, and this is the bone of my contention, it does not make the contents of these documents admissible as proof of the truth of what they assert. If a party wishes to rely on the contents, the author must be called or the document must be admitted under hearsay exception rule, that is 31C of the Hearsay Evidence Act, my Lord. And the same principle we submit, my Lord, that they are applicable here. Whilst we say that the state may hold the call data records up to Mngube and say, and I quote, do you deny that you communicated with Mabunguntuli? That is confrontation. That is admissible. But the moment the state prosecutor asks the court to draw an inference that the records are accurate, or worse, to treat them as rebuttable proof of the facts they contain, then we submit, my Lord, that the state crosses the line from confrontation to proof, and that the jurisdictional requirements for admissibility kick in. Those were, my Lord, the asides. Now let's come to the gravamen of why we are arguing and we are presenting these heads of arguments, and that is found at paragraph C, which are the jurisdictional requirements for computer-generated real evidence. And then, my Lord will see at C1, I just made a note for myself to say, automatically generated data is equal to real evidence, but only if foundation is laid. At paragraph 7, my Lord, we refer respectfully the Honorable Court to the matter of SABC Ndiki, and the citation is there, my Lord, where the Honorable Judge Van Zyl said, and I quote, evidence that depends solely on the reliability and accuracy of computer itself and its operating systems or programs contains real evidence, and I close quote. And then, my Lord, I argued this, that the corollary is the same if the state must lead evidence about the reliability and accuracy of the system of the data that produce that evidence, my Lord. The court cannot simply accept a printout because it looks official. Now I come to the case, my Lord, that I've respectfully referred the Honorable Court to, and I've also handed the case up, which is pertinent to the arguments here. The position in Ndiki we submit, my Lord, was confirmed in Mohapi Thabo and Anada versus the state, and this case, my Lord, was decided on the 21st of May, 2026, and it's a full bench, like I said, my Lord, emanating from the South Gauteng High Court, which is a division of these courts. Since it's a full bench, stare decisis says it is binding on this Honorable Court, my Lord. Before I go to Mohapi, my Lord, in order for us to understand the principles enunciated in Mohapi, I must state the facts in Mohapi. Mohapi and others were convicted on serious offenses. Then they appealed their convictions and sentences. The arguments raised by the appellants were the following. One, they denied ownership of the cell phone that was found on one of the convicted persons. And secondly, importantly, they raised the issue that since the state led evidence of cell phone records, and the state had indicated that they were going to call an officer from Vodacom to testify to those records. Yet, the state closed its case, my lord, and did not call the Petro Heineke from Vodacom, but instead, 2 senior police officials, 2 lieutenant colonels, Nietleng and Snell, testified regarding the said cell phone records. Now, the court, in determining whether those records should be admissible as real evidence, is it necessary for an officer from the telecommunication company to have testified on those records? Otherwise, according to the appellants, they were inadmissible, or whether it is not necessary for the telecommunications officer to testify so long as competent evidence was laid on those records by competent personnel, so even police officers. And this is what Mohapi established, my lord. Mohapi said, my lord, it is not necessary for the state to call the cell phone provider officer to testify on the records, as long as before the witnesses were confronted with those records, 2 police officers that testified on the records, and they had extensive knowledge. One officer was 25 years testifying on cell phone records. The court accepted that is competent witnesses, that is competent evidence led before a witness is confronted with the cell phone records to test the following: reliability, integrity, and how they were produced. In this instance, that is lacking, my lord. That is lacking. The state seeks to confront Mr. Mngube purely with printouts, without doing what Mohapi says. And the relevant paragraphs, my lord, that I will refer the Honorable Court to is paragraph 38 of the Mohapi judgment, because if I'm going to read, it's going to take time, but the relevant paragraphs are, and at page 9 of the judgment of Mohapi that I've handed up to the court, my lord, is this. Paragraph 38, and I read. The legal question arises as to whether the failure to call Heineke renders the entirety of the evidence of Lieutenant Colonel Schnell as admissible, or whether the interests of justice permit the admission of such evidence notwithstanding omission. A further legal question which arises is whether cell phone records should be classified as documentary or real evidence. And then the court at paragraph 39 refers to the matter of Kappa. We've dealt with Kappa in this court on numerous heads of argument, my lord. The citations are of record, but if we need a reference to Kappa, it will be Kappa versus S 2023 1 SACR 583 CC, and it was delivered on the 24th of January 2023. Now, at paragraph 39, the court says in Mohapi, in the matter of Kappa versus S, the Constitutional Court held that, and I quote, although the concept of a fair trial is a convenience of our common law jurisprudence, not every minor irregularity vitiates the right to a fair trial, and further states, Section 3531 of the Constitution guarantees the right to adduce and challenge evidence. In Ndlovu, and we've also dealt with Ndlovu in this court ad nauseam, my lord. In Ndlovu, the Supreme Court of Appeal clarified that Section 3531 does not create an automatic right to cross-examination. The Supreme Court of Appeal said that the Bill of Rights does not guarantee an entrenchment subject to all evidence to cross-examination. What it contains is the right, subject to limitation in terms of Section 36, to challenge evidence. Where that evidence is hearsay, the right entails that the accused is entitled to resist its admission and to scrutinize its probative value, including its reliability. The provisions enshrined in this enshrined these entitlements. But where the interest of justice, constitutionally measured, requires the that hearsay to be admitted, no constitutional right is infringed. Put differently, where the interest of justice require that the hearsay statement be admitted, the right to challenge and adduce evidence does not constitute the right to cross-examine the original declarant, and that's the emphasis that the court put. So in line with CAPA at paragraph 40 in Mohapi, in line with the CAPA decision, the court ultimately had the discretion to determine evidentiary weight of the cell phone data presented by the state. At paragraph 41, my lord, and the court will bear with me because this is very important to the issues that we're determining here. So, like I said at the beginning of my heads of argument, I'm going to quote extensively from Mohapi. Paragraph 41, courts do not automatically require an employee from Vodacom, MTN, or SABC to testify as to their cell data. And here's the rider, my lord. As long as someone competent can come and explain how the data was obtained and why it is reliable. This is, in essence, would complete the authentication aspect of such data. I should read it again, my lord. It says, courts do not automatically require an employee from Vodacom, MTN, or SABC to testify as to the cell phone data. As long as someone competent can explain how the data was obtained and why it is reliable. This, in essence, would complete the authentication aspect of this data. And this is where we stand, my lord. We need somebody competent, whether from Vodacom, whether it's the police officers, to come and authenticate the data that the state wants to confront Mr. Mncube with. And then at paragraph 42, my lord, as I hinted, the court referred to the experience of Lieutenant Colonel Snell, Lieutenant Colonel Nietling, and also, my lord, in that matter, besides the two police officers that testified, there was a Mr. Budai. He was a Vodacom engineer that dealt with maps and towers and how towers work, and interpreted how the towers worked at the time the offense in Mohapi occurred. This has not happened in this matter, my lord. Now, at paragraph 43, in Mohapi, it says, in the matter in Kasu, the value of the evidence dependent on the credibility of Lieutenant Colonel Schnell, Lieutenant Colonel Nietling, and Mr. Budia, the one that I said he was from Vodacom, who testified on the maps and the towers, my lord. That evidence met the requirements of the law of evidence. Regarding the authenticity and integrity of the cell phone data, it was never put to any of the witnesses that the cell phone records had been tampered with. So the issue of tampering relates to the reliability of that evidence, my lord. And at paragraph 44, page 11 of Mohapi, my lord, the court proceeded to say it is not an absolute universal requirement to have a dedicated cell phone expert to prove the admissibility of the cell phone records. The admissibility is governed by the general principles of evidence. As a result, the court finds that there was no misdirection on the part of the court of co. But the essence of, my lord, of the judgment that I've handed up of Mohapi is that, and that's my standpoint, that I've said I do not have a qualm if Mr. Mncube is confronted with the cell phone data of Mr. Mabunguntuli. The qualm is to meet squarely the requirements of CAPA. And as Mr. Munisi says, they then can have a field day in putting relevant questions to him based on those call data records, my lord. And then, in fact, my lord, let me go to something very pivotal. The case note of Mohapi says, and I want to put it on record, it reads, cell phone records, and in brackets, data generated automatically by a telecommunication system, close bracket, are admissible as evidence, even without formal authentication by a service provider witness, provided that their reliability, integrity, and method of production are sufficiently established through competent evidence. Such records may, they're not saying are, they say may constitute real and not hearsay evidence or documentary evidence. So the head note says a lot, my lord. It is loaded. So at paragraph 9, I continue with my heads, my lord. So the principle is therefore, and I'm saying the principle from Mohapi, says automatically generated call data records are real evidence, but the state must first lay a foundation through competent evidence as to how they were generated, how they were obtained, why it can be regarded as reliable, and that they have not been tampered with. And I'm not thumbsucking this, my lord. They come from a full bench in Mohapi. Now we submit that, my lord, at paragraph 10 of our heads, that the state has never laid that basis as required from Ndiki that I cited in paragraph 7 and in Mohapi as well. They've not led evidence from any competent witness explaining their generation, their integrity, or the reliability of those call data records, my lord. And we submit, my lord, and the court has heard this, that the state says they have obtained those call data records 3 days ago or so, yet these are records from 2015. And in order to understand this, because people will be asking why do they have records of 2015, we must recall the evidence of Ms. Pinky Vaitilingen to say, once call data records are requested by law enforcement, they remain active at the nodal point, at the front end of NEMO's system. And any subsequent police investigations that want to have access to that data, they'll always find it. So the 3-year period for that does not apply because they were previously requested in 2015. So when this new team led by Brigadier Gininda took over this investigation, the first point where they went was the nodal system of NEMOS and have access to this, my lord. So this is not new information, it's old information that's been available to the investigative team. So we say further, my lord, in our submissions that the Mohapi principle does not dispense with the need for foundational evidence. It merely permits the foundation to be laid by witnesses other than witnesses from the service provider themselves. Now, at paragraph C2, my lord, I'm making a very important distinction between Mohapi and S versus Brown. When electronic evidence is documentary and it is not real. At paragraph 11 of my heads, my lord, I submit. In S versus Brown, Bozalek J held that had to decide whether images downloaded from a mobile phone were real or documentary evidence. The learned judge held that because the images involved human creation and manipulation, they were more appropriately treated as documentary evidence, requiring proof of authenticity and originality. And we know this with photographs, my lord. He distinguished automatically generated network data from human-created content stored on a device. And how do we apply here? At paragraph 12 of our heads, my lord. Even if the raw cell data, my lord, we submit, the tower stems, the tower locations could be treated as real evidence. Any content attributed to Mabunguntuli, that is messages, notes, or any input requiring his credibility, is not automatically generated by the network. It is human-created content, and that will be documentary evidence. That would not be real evidence. And we argued, my lord, that under Brown, such content is documentary evidence. It's not real evidence, what exactly I've just said. And as documentary evidence, its admissibility depends on the ordinary rules. It must be authenticated, and if it depends on the deceased credibility, we argue, my lord, it is hearsay. Now, my lord, at the beginning of my address, I said we object on 2 grounds. The second ground was that my learned colleagues from the state relied on the Electronic Communications and Transaction Act 25 of 2002. And at the beginning, I said that does not assist the state. It does not avail the state. And we say that reliance on ACTA, section 15.4 thereof, is misplaced, my lord, with respect. And section 15.4 provides that, and I quote, a data message made by a person in the ordinary course of business, or a copy or a printout of or an extract from such data message certified to be correct by an officer in the service of such a person. It is on its mere production in a civil, criminal, administrative, or disciplinary proceedings admissible in evidence against any person and rebuttable proof of the facts contained in such record, copy, printout, or extract. The gist, my lord, is from that message, it must be certified to be correct by an officer in the service of such a person. Exactly what we are saying. Although, my lord, the rider that I put at the beginning, I don't know whether these certifications are there. I've never had sight of the call data records. But the certification precedes what Advocate Baloy said, we must stress that on its mere production, but you only merely producing something that is already certified to be correct by an officer who is in the employ of such an organization that holds these records. So the mere production of it is irrelevant if it's not certified. And we submit, my lord, at paragraph 14, that there are two jurisdictional hurdles the state cannot clear. And at 14A, we say the certification requirement. If the state is producing a printout or an extract of a business record of which a CDR would be, it must be certified to be correct by an officer in the service of that person, the service provider. The records are not certified, and without the certificate, my lord, from the service provider, we submit the printouts do not qualify to be handed up or to be confronted the witness in terms of section 15.4, because the requirement in 15.4 would not be met, my lord. That's my submission. And then B, we said there are two jurisdictional hurdles that they cannot jump. The second one in B, we submit, my lord, section 15.4 does not override the hearsay rule for human-created content. For example, we are not sure whether Mr. Mnube is going to be confronted with notes, with photos, and whatever data that the state wants to confront. But as long as it involves human creation, we kick in section 31C of the 1988 Act, the Hearsay Act, my lord. So we submit, my lord, even if the CDRs or the call data records were certified, section 15.4 only renders the business records admissible as rebuttable proof of the facts contained in it. It does not render admissible any content that depends on the credibility of the deceased Mabunguntuli. And at paragraph 15, my lord, we submit, as the court has held in Ndlovu versus Minister of Correctional Services, the actor, and I quote, the actor does not render data messages admissible without further ado. The Act provides the exclusion from evidence of a data message on the mere grounds that it was generated by a computer and not a natural person. In Ndlovu, the court found that the computer printouts were admissible, but not in terms of section 15 of ACTA. Rather, under the court's statutory discretion to admit hearsay evidence. And we submit, my lord, that this confirms that section 15.4 is not a freestanding getaway that bypasses the law of evidence, the hearsay, LEEA, the Law of Evidence Amendment Act 45 of 1988. And because of that, my lord, at paragraph E, I'll skip that because I'm not sure whether the matter that they want to confront the witness with, it's a matter that involves notes, messages, or anything that is dependent on the credibility of the deceased person. But if they do, my lord, then I'll make objections at the time relating to the procedure also that must be adopted in terms of and in line with my heads of arguments, my lord. Now, the question is, at paragraph F, my lord, of our heads of arguments, can the state use the records in cross-examination that it has never led in its case? My lord, we acknowledge, and it's a well-known fact, that the state can generally cross-examine on anything, even undisclosed material. That has never been my issue. And this is a very broad proposition. But in the light of this, what I've said, my lord, that This information, the Cleveland CAS 92/6/2015, I'm not sure about the cell phone records because I've never referred to cell phone records during my engagement with Mr. Mngube, and I've never had sight until they were mentioned here in court, even though I've got some disclosure from the Cleveland docket. We say, my lord, the state cannot use cross-examination as a backdoor to introduce evidence that it failed to lay a foundation for in its own case. And particularly where, and we say, one, the evidence requires authentication according to Mohapi and Ndiki. B, the evidence is hearsay and no application has been made in terms of Ndlovu and Kapa. And C, the evidence was known to the state since 2015 but was never disclosed, depriving the defense of the opportunity to verify its integrity, its reliability, how it was produced, or to prepare a response as we are doing now. We are doing a response in vacuum. I'm doing that in a vacuum because I've never had sight of the CDRs that they want to confront Mr. Mngube with. And at paragraph 24 of our heads, my lord, we say, in Gauteng, that I've referred to earlier against PRASA, the Supreme Court of Appeal found that the High Court had materially misdirected itself by relying on the contents of these discovered documents that were never properly admitted. The court noted that the appellant had never been cross-examined on what he may or may not have told the medical personnel and was therefore denied the opportunity to respond to the hypothesis advanced by PRASA. This underscores that even where a document is put to a witness, if the state then seeks to rely on its content without proper foundation, it commits a misdirection. Paragraph G of our heads, my lord. And it deals specifically with the specific distinction that is confrontation versus credibility when it relates to cell phone records. And again, my lord, I'm going to stress this. I'm not saying the state should not cross-examine Mr. Mngube. Once the jurisdictional requirements met in Ndiki and Mohapi are met, the state has got a field day with Mr. Mngube. Now, my lord, I just want to clarify this one. In response to the state saying that in my interaction with Mr. Mngube, I referred to a photo album and also general strokes that disclosure was made to the defense regarding the Cleveland case 96 of 2015. Everybody who was in this court will note that I did not refer Mr. Mngube to any photo album or to any specific photo. Before that process got started, Mr. Mngube said, Mr. Ramsepele, I'm not comfortable with you going there. Leave it, let me focus on the Senzo Meyiwa case. And that aspect was never pursued. So nothing was put on record in this court. And this honorable court can bear testimony that it has never seen any photo or any album referred to by the state in its heads that I referred Mr. Mngube to during our interaction, my lord. So that is a misnomer to say that I referred Mr. Mngube to a photo album or a specific photo for that matter. And regarding, my lord, the disclosure, although it is not material for me, especially for Mr. Ntanzi, and I don't believe for Mr. Mngube for that matter, of the Cleveland case pertaining to their cell phone records, my lord, I hinted at the beginning of my submissions to say what I have in my disclosure is not what Mr. Mngube have. I've never seen the cell phone records. Mr. Mngube does have them on his disclosure. My file does not have the cell phone records. So I've never had sight of those. So to say bravely that disclosure was made and the defense are aware of 1, 2, 3, 4, 5 is partially incorrect, my lord. Mr. Munisi, for example, was asking me, Mr. Ramsipil, what are people talking about Cleveland? I've never had sight of this except Exhibit Triple G. So what we were finished with as disclosure differs from legal rep to legal rep, my lord. Now, my lord, this is the dilemma. I'm coming to the end of what must then happen. The state has closed its case. It's about to embark on cross-examination of Mr. Mngube. Nobody says they cannot do it, but procedurally, where does the procedure leave them? They cannot do that in the midst of cross-examination. We know that, for example, that quotation from Justice Cameron that says the accused person cannot be ambushed with sudden evidence that was never disclosed to him here. And that was in Indlove, where he said, where hearsay evidence plays a decisive or significant part in convicting an accused, it should be admitted, and I quote, if there's compelling justification for doing so. I look for the continuation of this quotation. There's a specific one that says, you cannot, at the 11th hour, come up with new evidence that needs authentication that has never been authenticated, and you want to confront the witness with that. I look for the specific paragraph. But I was at this point, my lord, of procedure. Where does it leave the state now? Because they've closed their case, and according to Mohapi, in order for them to embark on that line of cross-examination with respect to the call data records, they must call competent witness who can testify to the integrity, the production, and the reliability, all of those factors that are mentioned in Mohapi. How are they going to do it in the defense case? I submit, my lord, that the solution is easy. The state has a recourse at the end of accused number 5's case to stand up here with motivated heads of argument to say, my lord, Hepworth says this is not a game. And in fact, my lord, come to think of it, Hepworth does not assist them. Hepworth says we cannot treat a criminal trial as a game for omissions or mistakes. This was not an omission, I submit. This was a stratagem. This was a strategy. This was you making your bet. Now you lie on it. Because they knew of this evidence from 2015 that they found Telkom 3 days ago. It's completely neither here nor there. The investigating team, when they were doing what Brigadier Gaininda calls cold case analysis and cold case profiles, they gathered all these documents and dockets of all the accused persons, and they knew what was contained there. So this was a strategy which has bounced with egg on their faces. Now they realize, how do we get to use this evidence? The horse has bolted, my lord. They've closed their case on a strategy that they adopted. Hepworth is not helpful here. So what must they do? At the end of the case, stand up here, on good cause shown, make an application for the reopening of the state's case, call those competent witnesses that Mohapi says they must be called, and then confront Mr. Mngube after those witnesses with whatever call data records they wish to confront him with, my lord. So as I argue and stand up here and about to sit down, my lord, with all due respect, my humble submission is that the application for the state to confront Mr. Mngube with those call data records now, in the absence of admissibility requirements having been met in terms of CAPA that is binding on this honorable court, should be denied, my lord, as the court pleases.
Directed by the court, my lord. See, we are left with 15 minutes. Is it going to? I'm going to finish this document. I don't know. The court can direct. The court can direct me. I don't know, my lord.
Okay, yeah, if you can finish it and then we go tomorrow. Or you can do it tomorrow. Let's do it tomorrow.
15 minutes.
I suggest that the interpretation should be done immediately so that the accused will understand what submissions were made by counsel at that point in time when it's still fresh in his mind.
It's a document, my lord. The counsel took more than 15 minutes. So immediately it's not fair because now I'm asked to do it in 15 minutes. Mr. Ramsipile did it in more than 15 minutes, my lord. So I want to do it proper. That's why I'm asking the court for. I want to do it proper, not half, my lord.
Yeah. Mr. Mshololo wants it to be done now. Take 30 minutes, so be it.
My lord. So
If you take 30 minutes, I say so be it.
then it will be passed to the correctional officer's time, my lord.
Yeah, there's nothing we can do. I mean, this side, we don't want to be practical.
Asiqale lana ke mnumzana uNcube. Umnumzana kaMsipile uthi ke ngokufanayo naye uadvocate Mnisi akaphikisani ke nokuthi abashushisi abavumelekile ukuthi ke bakuhlome imibuzo noma bakubuze ngalokho abafuna ukuthi bakubuze ngakho. Kodwa ke kunamacala ke lana akhulume ngawo icala lika Thabo Mohapi, icala lika Ndiki. Uthi ke kukhona ekufanele bakwenze ngaphambi kokuthi ke bakubuze noma bakuhlome imibuzo ngabo lokho abafuna ukukubuza ngako, futhi ke nangokufanayo nenkulumo yakho advocate Mnisi ukuthi ke idocument lelo abashushisi abakhuluma ngalo abakaze balibone bona ke bengabameli. Manje ke abazi ukuthi ke yini ebhaliwe noma ke ekhona kulona idocument lelo, nokuthi futhi ke lona lamacala akhuluma ngawo uMohapi kanye naye uNdiki. Futhi kufanele ke kube nochwepheshe abababizayo beze la bezoqinisekisa ukuthi ke le mininingwane kamakhalekhukhwini wakhe uMabhungu Ntuli njengoba yena engasekho manje engake akwazi ukuthi ayiphendulele. Kube khona ke abantu ngaphambi kokuthi bakwenze lokho abababizayo, akusho ukuthi kufanele ukuthi ke kube abantu abasebenzela uVodacom nanoma yipi ke i-service provider, kusengenzeka kube ke yiphoyisa. Sikhona ke isibonela senzile lacala thizeni la khona ke inkantolo yabiza khona iphoyisa elimkantsho bomvu elinolwazi lwalokufakazi lazoqinisekisa ke lokho. Uthi ke yiloko abacelayo ukuthi ke inkantolo ikuvumele noma ke inkantolo ikusho ukuthi ke cha yebo bayasho bamele ukuthi hayi ukuthi anivumelekile ukuthi ke nikwenze lokho, kodwa ke okufanele ukuthi ke nikwenze ukuthi ke akubizwe labantu laba ukuthi ke bazoqinisekisa lokho. Uma siqala lana ke ku page 1 kuzona ke izethulo zakhe umnumzana kaMsipile uthi ke umbuso noma ke abashushisi bayimisele ukuthi ke bahlome imibuzo kuyena umnumzana uNcube okumsolo wesithathu ngayo imininingwane yama-record phecelezi ke i-CDR ephathelene noma ke eqondene naye uMabhungu Ntuli osengasekho kumanje nje. Lama records ke bawathole ngaphansi kwakhe ke usection 205 wawo umthetho ke u51 ka1977 uthi ke abasibekanga isisekelo ukuthi ke kungani ukuthi ke kufanele inkantolo ibavumele noma ke inkantolo ivume ukuthi ke bakwenze lokho nanjengobufakazi ekuyibona ubufakazi ke obuphathekayo ngokomthetho waseKota wona ke umthetho u45 ka1988 abameli noma ke umeli ke abahambisani nalokho ukuthi ke kusetshenziswe leyo mniningwane phecelezi ama-CDR lingaziwa ke iqiniso laloko okukhona noma ke okubhaliwe lapho nanjengoba engekho umnikazi wako lokho okuyena uMabhungu Ntuli futhi ke kungekho nofakazi obiziwe futhi ke okunye bangela ukuthi ke abameli babe nenkinga yalokho ukuthi ke bona ke abakunikeziwe lokhu umbuso noma abashushisi ke abazimisela ukuthi ke babuze ngako ngokomthetho ke noma kwenqubomgomo lokho ke akusiyona indlela yokwenza impendulo ke emfushane ke kulombuzo ke ukuthi abashushisi basengahloma yini imibuzo kumnxeba ngemininingwane yakamakhalekhukhwini abangakaze bayinikeze kubameli kulona umbuso ke ungakwenza lokho ukuthi ke umhlobo imibuzo umncube ngawo lama record noma ke lama CDR ukubheka ke ukuthembeka kwakhe kodwa angeke ize ibambe kube yinto ebambelela noma encika kuyona ke leyo ebhaliwe noma ke ekhona lapho nanjengobufakazi bokuthi ke kuyiqiniso lokho abakushoyo noma ke ekuyikona ekulindelekile noma ke ekwamukelekile ukuthi ke inkantolo ibuthathe noma ke ikwamukele nanjengobufakazi ubufakazi ke okutholiweke ubuya kona ke icomputer nanjengobufakazi okuyibona obungasetshenziswa kuleli cala leli ke esibhekele nalo lokhu ke noma lokho okufanelekile akwenziwanga ngaphansi kwawo umthetho lona ke abakhotile section 15 wakhe ngaphansi kwakhe u4 manje ke umehluko ke ukhona ilona ukuthi ke uhlonywe imibuzo kanye futhi ke nobufakazi baloko okubhaliwe ngaphakathi lapho umthetho ke uyabuhlukanisa ke lokho ukuthi ke uhlonywe imibuzo kubhekwa ke ukuthembeka kwakho ke kanye futhi ke abashushisi abasengakwenza ke ukuthi babeke ke amaphepha la noma ke i-document leli balibeke phambi kwakho noma phambi kwakhe ufakazi ukubheka ke inkulumo yakhe uqhathanisa nenkulumo yakhe babheke futhi ke nokukhumbula noma indlela yakhe akhumbula ngayo nokuthi futhi ke kubekwe ke nesisekelo ke sokuthi ke kungani ke esehlaselwa noma ke kuhlaselwa ukuthembeka kwakhe futhi ke i-document leyo kufanele futhi ke lamukelwe ngendlela efanelekile nanjengobufakazi kodwa ke ufakazi kufanele anikezwe ithuba elanele lokuthi ke abhekane nako lokho noma ke amaphepha lawo kubhekwe futhi ke nobufakazi bokuthi ke kuyiqiniso kangakanani noma yiqiniso yini lokho okukhona okubhaliwe lapho ngaphakathi mshushisi ufuna ke inkantolo lena yamukele lokho okubhaliwe kulelo document lelo nanjengeqiniso amarekhodi ayakhombisa ukuthi uMabhungu Ntuli noma ukuthi ama-record ayakhombisa ukuthi uMabhungu Ntuli waxhumana nomsola wesithathu ibhala isikhathi lapha 2015 kufanele futhi ke lamukele nanjengobufakazi ke futhi ke abashushisi fanele ke futhi babeke isisekelo ekuyisona nesifanelekile phambi kwenkantolo ukuthi ke kungani ke bekwenza lokho wasekota ke lana icala ke alisebenzisa nanjengesibonelo icala lakhe uGautini kanye naye ke iPrasa Passenger Rail Agent Service of South Africa necase number ibhaliwe lapho ke inkantolo yokudluliswa kwamacala yathi ke isivumelwano sokuthi ke onke ama documents ekuyiwona ke ekufanele ukuthi kunikezelwane ngawo ngaba ayikona yini lokho akushoyo ukuthi ke ayikona kuvumela ke ukuthi lawo ma documents lawo ke uma ngabe setholakele ke wonke ke nanjengobufakazi futhi ke ufakazi obuphathekayo kodwa ke ayenzi ukuthi ke lokho okubhaliwe lapho kulawo maphepha lawo noma ke phecelezi ke ama documents abe ubufakazi ke obamukelekile nanjengeqiniso aloko akushoyo ukuthi ke ayikona. Uma ngabe ke kunomuntu ke ofisayo ukuthi ke ancikeke kuloko okubhaliwe kulokho umnikazi noma ke loyo okuyena okubhalile lokho okulapho fanele ukuthi ke abizwe noma ke amaphepha lawo ama documents kufanele ke amukelwe ke ngaphansi ke kumthetho ko ohambisana nomthetho wenzwabethi. Nalana ke kulecala esibhekele nalo ke kufanele ukuthi ke kwenzeke kanjalo ukuthi ke umbuso usengathi ke ube nawo ke lama record noma ke uthi ke kuyena ke umncube ingabe uyaphika yini ukuthi waxhumana naye uMabhungu Ntuli lokho ke ukuthi ke uqondana naye. Kodwa ke uma ngabe umshushisi esebuza noma esecela inkantolo ukuthi inkantolo manje ayifikelele kwisinqumo ukuthi ke lawo ma documents noma lawo ma records lawo ngempela ayiqiniso noma ke lokho okulapho kuona kuyikona nokuthi futhi ke kuwubufakazi obungaphikiseka noma ke obuphikisekayo amaqiniso ke lawo enawo noma ke ewaphethe. Manje ke sokusho ukuthi ke manje umshushisi useqa umuqa ke ngokwenza lokho ukusuka ke manje ukuthini aqondane naye ufakazi ekuthini manje sekweqela ekuthini kuwubufakazi lobo phambi kwayo inkantolo. Uyaqala ke besikhulume ngalo uState versus uNdiki ka 2007 lana ke uFansale esho ke khona ke ukuthi ubufakazi buncike ekuthini bufakazi obuqondile yini buyamukeleka kwicomputer yona uqobo kanye futhi ke neindlela zayo noma ke inhlelo zayo amaphecelezi ke ama program ukuthi ke kungamukelwa nanjengobufakazi ekuyibona masidlulela kulona ke elikaMuhapi uThabo kanye ke futhi nabanye 21 May 2026 kusho ukuthi ke isiqumo ke sakhushwa ngawo lo nyaka la inkantolo eyasho khona ukuthi ungabi khona komuntu noma ke ufakazi obuya kwa Vodacom ukuthi ke azoqinisekisa ukuthi ke lokho okushiwo lapha yana ngempela kuyikona ukuthi ke lokho ke kwakuyinto eyayisemqoka kakhulu ngoba ke manje umbuso noma ke abashushisi lapho bathi ke baletha ubufakazi obunganele noma ke obungaphelele obuya ke kwabanye abantu amaphoyisa kanye futhi ke nabantu ke noma omunye oyedwa uengineer obuya kwa Vodacom owachaza ukuthi ke idatha nemininingwane ihlanganiswa kanjani itholakala kanjani nokuhunyushwa nokuchazwa kwayo. Inkantolo ke kaMuhapi yagxila ke ekuthini ama records lawo enziwa kwaba ke ukuthi ke enziwe ke automatically ngokuthi kusetshenziswe ke ezokuxhumana noma ke ama system ezokuxhumana ngaphandle kokuthi ke kube khona ke umuntu okwenzayo lokho. Futhi ke nalana kulecala leli abashushisi ke isekelo lezi ke ekukhulunywa ngazo kwicala likaNdiki nelikaMuhapi abazilethanga lana noma ke abashongo phambi kwale nkantolo ngokwandlela ekulindeleke ngayo kuNdiki nakuMuhapi ukuthi ke kulethwe ubufakazi noma kuze lobo bufakazi lobo. Naloko abakushilo futhi ke ukuthi ubufakazi lobu ke bakuthole kumalanga amathathu adlule noma andlule abakwazi ukuthi sebengasebenzisa kuphela ke ama print outs base balindeleke ukuthi ke inkantolo ikwamukele lokho. Icala ke lika Brown 2015 128 uBozalek J yena ke isinqumo awasithatha ukuthi ke izithombe lezo ezazi downloadiwe kusetshenziswa wona umakhalekhukhwini ukuthi kwakuwubufakazi bangempela yini noma ke kwakuyisinqumo leso fanele ke asithathe wase ethatha isinqumo ke sokuthi ngoba izithombe lezo ke kwakuhlanganise nokuthi ke kube nesandla somuntu phakathi noma ke umuntu wayekhona ke owakwenza lokho ke kwathathwa akuzange kuthathe njengobufakazi okuyibona kodwa ke ubufakazi nje obenziwa kusetshenziswa wona umakhalekhukhwini. Uma ngabe ke ungathi kusetshenziswa imininingwane lena ke ama stamps amathawa ama locations kungathi ke kuthathwe ke njengobufakazi okuyibona nanoma yini ke ehlanganiswa naye uMabhungu Ntuli ama message ama notes nanoma yini lokho ke kuzodinga ke okubuya ke noma ke ukuthembeka okubuya kuyena akusiyona ke leyo into eyenziwa yi network kodwa yinto eyenziwa ke isandla somuntu ngaphansi kwakhe ke uBrown okunjalo kodwa lokho kona ke akuzange kuthiwa kwakunomuntu owayesebenzisa isandla sakhe lapho kungasibona ke ubufakazi bangempela ngoba ubufakazi obuyiqiniso. Lana ke uMr Ramsupile ukota ke noma usebenzisa ke umthetho lo ongu-15.4 we-ECTA ukuthi ke lokho akubasizi ngalutho abeshushisi ukuthi ke abashushisi bancikeke kuwona lo mthetho u-15.4 we-electronic communications noma ke ezokuxhumana 25 ka-2002 ukuthi lokho ke abakushilo noma abakubekanga ngendlela u-section 15.4 yena ke akushoyo ukuthi ke imininingwane ama-message edata enziwe umuntu noma ke amakhophi noma ama-print out abuya ke kwimininingwane ekanjalo ukuthi ke kube nomuntu ke oqinisekisayo ukuthi ke ngempela ke lokho yebo kuyikona. Ukuthi ke kube ubufakazi ke obamukelekayo ngakuyena ke umuntu lo so noma ubufakazi obungathi busetshenziswa ke kuyena ke umuntu lo futhi ke kube ubufakazi obungathi buphikiseke amaqiniso akho yinto engathi ke iphikiseke ubili ke lana ekufanele ukuthi ke kubhekwe kona ke ukuthi ke yilokho okulindelekile ngoba ke kune certificate ekufanele ukuthi ngaba sibe khona uma ngabe ke umbuso noma abashushisi bekhipha ke ama print out noma ke ama business record ekuyi CDR ebuya ke service provider laba ke abasebenza ngomakhalekhukhwini kufanele ke lokho kuqinisekiswe ukuthi ke ngempela kuyikona umuntu ke owenzayo loyo msebenzi phecelezi ke i-service provider kuleyo ndawo leyo esebenza ngabo makhalekhukhwini ama record lana ekhulunywa ngawo lana ke awaqinisekisiwe. So Mr. Ramsapil, is it the section 15.4 which you skipped? You said you are not sure about all. There's one that you skipped, sorry.
Yeah, section D.
Oh, not D. Okay, sorry. Bese kubaneleke ke icala lakhe ke uNdlovu kanye naye ke uMinister we-Correctional Service la ngo-2004 ukuthi ke lo mthetho lona obizwa ngokuthi ke ECTA awusho ke ukuthi ke ama messages noma ama data messages ukuthi ke ubufakazi obungamukeleka lokho ngaphandle obungamukeleka phambi kwayo inkantolo noma ke umthetho okunqabayo ukukhishwa ke kubufakazi bama message edata ngokuthi kwenziwe ngokuthi kusetshenziswe ke ama computer kodwa ke hayi ukuthi kwenziwe lokho umuntu kulelo cala likaNdlovu ke okwatholwa inkantolo ukuthi ke lawo ma print outs lawo ubufakazi inkantolo eyayingabuthatha ke ithi ke iyabamukela ilana ngaba ukuthi kona ku uthe ngoba uthe akakuboni ke lokho uMr Ramsipile angeke ke agqile noma angene kuloko ngoba akazi ke ukuthi ke yini ekhona kulawo ma documents lawo. lana ke masiku F ingabe umshushisi uyakwazi yini ukuthi ke asebenzise ama records uma ngabe sehloma ke ngemibuzo kodwa into leyo abangakaze bayenzeke ngesikhathi ke bona kuyibona ke abethula ubufakazi phambi kwenkantolo. Abameli bayavuma noma umeli uyavuma ke ukuthi istate noma ke abashushisi basengaqhubeka ke bathi bahlome imibuzo na kunanoma yini futhi ke nalokho ke abangakulethile noma ke abangadalulile phambi kwayo inkantolo kodwa ke abakwazi ke ukuthi bangathi ke bahlome imibuzo ngokuthi ke basebenziseke manje ukuthi ke bangene ngesitapha sangasemuva balethe ubufakazi ke abangabethulile noma ke abangasilethanga isisekelo ngesikhathi bona ke bethula obabo ubufakazi phambi kwenkantolo. La khona ke ubufakazi lokho budinga khona ukuqinisekiswa nanjengoba uMohapi noNdiki besho kanjalo ukuthi ubufakazi lobo ke buyinzwa bethi futhi ke asikho nesicelo esenziwe setshenziswa yena ke uNdlovu noKapa futhi ke ubufakazi lobu ke ababe nolwazi lwabo ukusuka ke ngaye u2015 kodwa ke abakaze babudalule ubufakazi lobo manje ke sebenqabela ke abameli ithuba lokuthi baqinisekiseke nokuthi futhi bayilungiselele impendulo ukona lokho phinda futhi kakhuluma ngalo icala leli lika Gauteng kanye naye ke iPassenger Rail Agency ukuthi lapho ke inkantolo yokudluliswa kwamacala yathola ukuthi ke inkantolo ephakeme nephutha ke eyalenza lapho ngokuthi ke incike kuloko okubhaliwe kulawo ma documents lawo kodwa ke awangakaze amukeleke noma ke alethwe ngendlela efanelekile phambi kwayo inkantolo nokuthi ke akaze futhi kube nethuba ke lokuthi ke ufakazi ke ahlonywe imibuzo ngako lokho okwakukhona ke kulawo ma documents lawo. Akucelayo ke egcineni umnumzane kaMsipili ukuthi cha hayi ukuthi ke abashushise abavumelekile ukuthi ke bangakubuza ngaloko abafuna ukubuza ngako kodwa ke lama documents abathi bawatholile noma ke le 205 yakhe uMabhungu Ntuli bathi bayitholile abameli abatholanga isikhathi sokuthi ke babone ukuthi ke yini ebhaliwe lapho umnikazi ke walawo ma documents lawo akekho nokuthi futhi akekho kufanele kube nomuntu olethwayo obizwayo azoma khona lana azoqinisekisa ukuthi leya 205 elapha yana ngempela kuyikona noma kuyiqiniso lokho okubhaliwe kuyona yiloko abakucelayo uadvocate Mnisi kanye naye futhi ubaba uRamsipili.
My lord, I think we have reached the business of the day. May I proceed tomorrow with my heads? Thank you.
Yeah, tomorrow then.